But how can the governor say this? Kindly read 7. Is it possible? Forget the right or wrong. Why should the governor say it? How can he say it constitutionally is my question to myself. Dear Shri Uddhavji, the governor writes to the Chief Minister, I am therefore confident that you and your government has lost the trust of the House and the government is a minority. Now just pause and look at let's just forget this case for 2 minutes. Look at the consequences of this letter in the constitutional and the juristic sense. Number 1, it is a certification by an executive nominee that the departing allegedly disqualified members, allegedly by me, are kosher. They are not disqualified. They are not disqualified is his confidence. Number 2, that you, Mr. Uddhav, is not the Shiva Sena, but those people are. He is writing to Uddhav Thackeray. 3, he is doing it under the nose of a pending disqualification, 10 scheduled proceeding and a hotly contested Supreme Court matter. The ordinary mortals who are doing it, the Lordship take a very serious view. I know the Lordships can't issue directions to the governor and content may not lie. But just consider, Manoj, if anybody else would write a letter like this, when your Lordship is hearing such a heavily contested matter and the Speaker is dealing with it, I don't know, Manoj, normally, Manoj, we'd expect some contempt notice. Then some appropriate case will have to examine how far the arc of immunity applies. Number 4, he is, Manoj, actually setting up the ground as a precursor. Come to me, I will swear you in. This is an advance intimation. This 7th para read as it is can only say, come to me, I am ready to swear you in. Because you are kosher. There is no problem with you, there is no stigma. Only step left is that, nothing is left. Therefore, Malaz, to the other question, my Lord, the Honorable Chief Justice asked me on Thursday, Malaz, what is it that you want us to do in the event that we agree with you? Or should put a question like that. One of the simplest levels, of course, I gave Your Lordship a larger answer, simplest level is to quash this letter. Now, suppose Your Lordship quashes this letter, just for a minute, and I do not press, except for 1 or 2 things, in any meaningful way for other things. Just suppose, I'm just not conceding anything, I'm just giving Your Lordship a supposition. The status quo ante is automatically restored. Lordship doesn't have to say it. And is that constitutional morality? Is that fair play? Is that upholding the greatest traditions of governance? Because clearly it is. And certainly, there can be no bar, immunity, hesitation, legal obstacle, constitutional bar from quashing this letter if Your Lordship otherwise agrees with me. The letter is not a non-quashable document, Manoj. It's a direct prayer, directly impugned in all the writ petition or many of the writ petitions. Take it, Manoj. Take it that it's impugned. The 5th is a obvious consequence of this consequence. Next step is swearing in, which happens on 30th. This is 28th, 30th. In fact, the seeds of that are very clear in para 7. I told you it's an advance intimation. It happens 2 days later. So that's a letter saying you are kosher. That is one of acting on the letter and giving you a constitutional status of a minister. Well, in fact, I'm sorry, that swearing in was the Chief Minister. 30th was the swearing of Mr. Shinde.
Chief Minister. 38th.
So you are swearing in a constitutional head of state. And what is the last consequence is again consequential to the consequence, which is appointment of the Speaker. If I may say the new Speaker or the Speaker. I have given Your Lordships 6 consequences. I mean, one can make probably 7 or 8 also, but let's say 6. Well, my respectful submission is A, that these are serious consequences, extremely serious for our constitutional polity. B, they are case neutral to the present case. They are extremely serious for our constitutional polity. B, they are case neutral from this present case. They are juristic questions and they are bound to recur unless Your Lordship plugs the loophole this way or that way. Third, these are all within Your Lordship's judicial domain. None of this is a no-go area. Fourth, and this is very important, Melissa. Fourth, only Your Lordship, I am not saying Your Lordships may, I am saying only Your Lordships can decide and should decide this. I am not even making an optional. According to me, this is only the Honorable Supreme Court which can and should decide it here, not delegated to any other authority. Then, Melissa, this is the main point, really. And then, of course, it follows that Your Lordship would, Melissa, as an ancillary, because Your Lordship passes ancillary
yes, now it
says, well, it's just 2 minutes more. But
I have one question, but I don't want to disturb your Lordship.
I'll just take about 10 minutes more. I'm going to make some. So, Your Lordship will therefore restore in the ancillary sense, the position as on 27th or such date. That is, ultimately your Lordship's orders are not spurics. They have to have an effect. That effect has to be only that restoration.
To restore position as on
27th August, June. That is, this is 28th, so 27th is one day before. Is interesting point, and not merger. Just see the irony here. Your Lordships has only one defense, fellows, apart from condonation of merger. Merger is the supreme irony in this case. Merger is not even alleged by them, claimed by them, raised by them. In case of a merger, suppose 8 out of 10, 6 out of 10, 9 out of 10 leave, the remaining chap left behind is protected. Under your Lordship's 10th schedule is protected. He otherwise he's a loner. He would himself be is protected. Here, but for Lordship's interim order, which we argued just a few days ago, I am not protected. Without claiming merger, today they are issuing letters and whips, which I am not talking about Lordship's protection. The whip is being issued as we speak, in various matters, they are entitled to it, if the EC has recognized them. But for Lordship's protection, I would be liable to be disqualified for not following his whip. Because without invoking merger, without getting a merger, there is no protection. They become the party. These are consequences. This is a consequence Lordship I add in my 6 consequences. This is a very weird consequence. It's a very weird consequence. If you have the defense of a constitution, you are worse off. If you don't take the defense of the constitution, you are better off. I'm very deeply obliged.
Just one question I had. It's a facts part. You said, and both Mr. Sibal also said the same thing, that this is not a case where a trust vote is called when the House is constituted for the first time. So that the governor's powers, of course, the governor has the power to call for a trust vote when there is no clear majority on the floor.
It's not after the election that you have for the first
time. It's not after the election because here the government is formed. Very valid point that, this is post-formation of government. What is the power of the governor to call for a trust vote post-formation of the government? What are the circumstances in which he can?
That means a running government.
A running government.
Correct. Well, let me answer on first principles. Of course, we can add some material and give your Lordships specifically and not only on this. But on first principles, the first answer is that zero, where your Lordship will decide abstract. Zero, answer to Lordship, direct question, direct answer. Zero power, where there are pending disqualification issues in a running government. Because Lordship should not mix up the two. One is a normal vanilla running government with no issue of disqualification. One is a disqualification pending at 2 levels. My candid, clear answer to your Lordship's direct question is zero. Number 2, the reason is what I have given It is a lateral entry of the executive in an area where there cannot be any jurisdiction. There is no locus in either 10th schedule or Lordship jurisdiction. Number 3, if your Lordship's question is premised, has to be premised and rightly premised on the assumption that the governor, what he does in the question posed by the Honorable Chief Justice, what is he doing, He is recognizing ABC as the inverted commas majority. There is no relevance to your Lordship's query unless the governor does that. Otherwise, your Lordship's query would not be relevant. Obviously, please suppose that he is giving some imparting legitimacy, recognition, or some status. How is that possible?
There's only one gray area.
In constitutional law, it's not possible.
Not so much from the facts of this case, but we're looking at now from the perspective. On the facts,
I tell Lordship,
when you read that letter of the 28th of June 2022, the governor, you said that what the governor essentially did was to recognize the split. By the letter. In fact, the letter does say that so many people have left you, and therefore, that.
Without using the word split, is a full recognition, my submission to Lordship.
De facto recognition of a split.
Yes.
Correct. Now, your answer to that is that the governor, so long as the disqualification petitions are pending, he cannot call for a trust vote for the simple reason that you are still a part then of the government which is supported when the House was formed.
Except in one case.
Right.
Where, for some freak reason which I cannot think of, it will never happen, then nobody decides to seek to disqualify the other. Now, let's suppose.
Often the speaker, what he may do is that look,
No,
I don't disqualify you at all.
No, but that is not so simple.
Then you contribute to the majority of the.
No, but I am doing a juristic answer to your Lordship's query. It can never arise in practice, but I am giving a juristic answer. That will have to be a situation where there is no cavil and dispute. I mean, it is virtually by consent of everybody. But with that answer comes a caveat. It goes back to the origin and the object of the 10th schedule. Why was it enacted? It was enacted not to encourage these trust board situations by defections. Unless that is so, it will rise every week, every 2 weeks.
One of the last point, maybe you can take 2 minutes to put this to the other side also.
Yes.
So what is the there's no clear answer.
No, I'm very grateful though, that helps us to clarify in our own minds also. Just to clarify.
There is in assessing the strength of a ruling party in the House, whether it's the Legislative Assembly or the Parliament, you have a numerator and you have a denominator. The numerator represents the strength of the party when the House was formed. The denominator represents the total strength of the House. Now, by calling for a trust vote on 28th of June 2022, the governor, according to you, your argument is that the governor therefore recognizes that a part of the numerator has evaporated or has been taken away.
It's rather nice you're putting in numerator.
Yes, the numerator has been taken away. And therefore now I feel you have lost the confidence in the House. According to you, that is not permissible because the disqualification petitions are still pending.
And he recognizes and gives legitimacy to the numerator. In your Lordship example, he is recognizing and giving legitimacy to the numerator.
The only problem which I think, which is kind of not, which is worrying is, does the governor not also recognize that the very act by which the numerator may or may not be affected? Alright? For instance, the numerator would be affected even if you don't treat it as a split, and there's a clear disqualification. Then the numerator is reduced by X, the strength of the ruling party in the House, minus Y, the people who have defected from, who have therefore attained disqualification. But equally, that same act affects the denominator also.
Because it reduces the total strength.
The total strength of the House.
Correct.
So, though the governor cannot therefore say, the governor cannot legitimately say that, look, these people have left you, therefore I want to trust.
Correct.
But can the governor not then say that, look, assuming that there is no recognizable concept of a split now under the 10th schedule, the effect of all this is that these people have to be reduced both from the numerator and the denominator.
Straight away. There are many answers. First, this exercise cannot be done by the governor because there is no mechanism for it generally.
You have been arguing that he can't assume to himself to take a decision.
First, we have Lordship 3 or 4 answers. Lordship will note down my very specific answer. This is an exercise itself which he cannot embark upon. The governor has no such jurisdiction to embark upon when there is a running house. Now, second answer.
Right. He can't embark. But can you not, therefore, then say, I want this exercise to be demonstrated on the floor?
No, I'm saying that exercise you can't embark. Let me answer.
Can you not?
He
has argued that.
Second answer.
Argued that he won't have the. It has to be.
Whereas numerator, denominator, you can't start with the fellows. Your Lordship has to premise a direction by me to him. I'm the governor. I'm giving him a direction.
So in other words,
please have the argument. You can't give a direction.
Got your point.